What's going on, world? It's your boy at Big Game James _36. And we got a special Den Media Group presents Law and Order FSU, FSU edition. I was gonna go get the Law and Order music, but I'm learned really quick in this game that if you want to stay monetized, don't get copyrighted trademark music. Stay away from that as much as possible unless you get it this thing called clearance, and they're probably not going to clear it for small time podcasts. And I like you guys, but I don't like you enough right now to just go for the pure value of or for the love of the game right now. So we got to go for the paper. Oh snap! I lost. So I say all this to say, use your imagination. But a lot of things have happened since the last time that I had Doug on, last time that I had Danielle Kelly, who will also be joining us over the course of this pod today. What's funny, though, is if you actually listened, we talked about a lot of what-if scenarios. And damn, if some of those what-if scenarios didn't kind of happen. So one of them is can you sue somebody before something actually happens? What happens if other people come involved? And as we talked with Danielle, there are a lot of other legal cases that the NCAA was battling. Now they might have just found their own. And like, what does this all mean from a billing perspective and then just other things? And we can talk, we can speculate. But the reality is, I'm not a lawyer. I just play one on Den Media Group sometimes on Monday, Wednesdays, or Fridays. But that's why we have an attorney. He's licensed in the Peach State of Georgia. He's a drinker of fine spirits. He's a great man. He's a Leo, so obviously Leos tell the truth and they're handsome. I didn't actually figure out, are you a July Leo or August Leo?
August, baby.
Okay, so he's an August Leo. Can't hold that against him. He's still a Leo nonetheless. He went to double graduate from Florida State University. Actually, technically, if you went to the law school, that would make you a 3 because you have to get don't you get your master's as well?
No, nope,
or you only got your Juris Doctorate
and bachelor's, and then your 3-year law school degree.
All right, so we got that, and just all around great guy. So Doug Rohan with Rohan Law, and just give your own brief introduction if you don't mind for the people who did not see us before or the people who haven't seen you on the 1,000 podcasts that you have been doing.
Thanks, James. I appreciate you having me. And look, I enjoy getting into the weeds with this stuff. I'm a fan and I want to know what's going on and I understand what's going on. But I do have my own law firm representing injured workers and people who have been charged with crimes, with criminal defense matters. So I spend a lot of time explaining the law to people who are experiencing this for the first time. So I pray and hope that none of your followers ever need me. I don't want you to have to call my office, but that's why I say we want to be your best friends on your worst day, because if you're calling me, then something really bad has happened. Either you've been injured at work, you've been injured in a car crash, you've been arrested, and you've got some dark days ahead of you. And if you want a fellow Knoll in Georgia to come alongside you, if you're in the Atlanta area or anywhere outside of Atlanta in the Georgia state, then we're here to help you at Rohan Law. We really do care, and we do really want to help, and especially our Knolls. We want to make sure that they're not confused and befuddled by this legal system.
Nice. And legalese is one of those things that I talk about. Sometimes when they start putting I call it that Old Testament language, the therefore and the thou arts, and when I start reading that New King James version, I'm like, hey man, just tell me what this says, man. I ain't got time for all of that, man. So can you kind of bring us up to date how we got to this place? So basically the lawsuits and filing in North Carolina, filing the state. So where we're at, catch everybody up in a brief synopsis, if you will.
So we've had a lot of excitement. That's why we've been on several podcasts, and we really appreciate the opportunity to meet with you and hang out with you. So this all started off with the notice that there was going to be a board of trustees meeting at FSU. They have to give 24 hours notice. And that was on was it January 20th? These days are running together at this point. I think it was December. It was back in December when all this happened.
Mm-hmm.
December 22nd, they announced a Board of Trustees meeting on December 23rd to discuss whether or not they were going to, well, they didn't even talk about what they were going to discuss. They just announced an emergency meeting. Well, as soon as that notice came out about the emergency Board of Trustees meeting, the ACC ran down to the Mecklenburg courthouse and filed this ready-made suit that they had sitting in somebody's drawer regarding a declaratory judgment action. So the ACC went to North Carolina courts and said, we want you to declare before there's any breach of contract that there is a valid grant of rights and that all the member institutions are responsible for upholding it. Well, of course, the next afternoon or next morning, the Board of Trustees met and authorized the filing of their own complaint in Tallahassee and Leon County. So the Board of Trustees filed in Florida State, in the state of Florida, a declaratory judgment action trying to get a judge to say, before we breach the contract, please tell us that this grant of rights is not valid. After that, a few weeks later, we have the ACC filing an amended complaint in North Carolina. This is very standard practice. The amended complaint includes some additional new details and tries to shore up some of the arguments of what they've alleged during the initial investigation process. Basically, what they did was they read the FSU complaint and tried to fill in some of the holes. So the ACC filed their amended complaint about 2 weeks ago. And then yesterday, the night before, 48 hours ago, Florida State filed its amended complaint in Tallahassee. And that amended complaint addressed some of the issues that the ACC tried to raise in its amended complaint. So we've got two different jurisdictions fighting over two amended complaints. Both parties have agreed that answers are due on February 16th. We'll talk about that in just a minute. But right now we have both parties alleging certain facts in front of the court. And now it's going to come down to what is the discovery that comes out as part of the investigation, and which of those facts can be substantiated. So we're now waiting to see, is this going to go to a quick solution? Are they going to be starting to mediate and settle right now? Or is this going to be working its way towards a trial, which would probably not happen in 2024? I would expect something more likely the middle of 2025 if this actually goes to a trial.
So with that being said, that would make trial doesn't benefit Florida State in the fact that it makes it a little bit longer before you get your answer. But I think one of the biggest key takeaways that we had at the last time for people who are like, why would you sue? Nothing changes if you don't sue. Like, you're literally, at the end of the day, you're either going to finish the contract and everything is going to be the way that it is now, or you're not going to be, or you're going to be able to get out of the contract and you stand to make more money. But the way as it stands, nothing changes now. So
yep, we talked about the fact that people are wondering, is FSU going to get hit? Is FSU going to have to pay $574 million? Remember, the status quo, the contract is, we just have to stay in the ACC until 2036. We still get that money. We're not going to have to pay $574 million. The question is, do we get a compromise? Do we get a settlement that lets us out for less? Or worst case scenario, we get dinged by the courts. They say, you wasted everybody's time. This is an ironclad contract. Now you owe attorney's fees. Okay, fine. We'll pay a couple $1 million. It was worth the time and effort to determine whether or not we can get out of this POS conference.
Gotcha. So they amended their complaint based upon what we had with our Board of Trustees meeting, basically saying that I guess by us meeting, we threatened to breach the contract, even though there were no minutes to the meeting available for them at the time that they did that. So Florida State did what exactly in response to that, in response to their amended complaint?
So the FSU amended complaint was the gloves are coming off. The ACC hasn't been reasonable. I'm sure that discussions have already started about what the resolution, what the divorce is going to look like. And it appears the ACC probably was not being very rational or reasonable. So Florida State decided we're going to start naming names. So in the amended complaint, they detailed specifically those issues that we discussed when this complaint first came out. First, the issue of the fiduciary duty. Florida State was alleging that ACC had an obligation under the Constitution and bylaws and stated publicly that give us your grant of rights, give us your rights to your home games, and we are going to negotiate a great deal in your favor, a better deal than you can negotiate on your own. And now in this amended complaints, that has been stripped down because they've outlined and detailed why nepotism between John Swofford and his son Chad Swofford over at Raycom was actually the overriding deal that managed and that played into the ACC negotiations in 2012 with ESPN. They've specifically mentioned conversations and newspapers that were published. And let me be very clear. Let me remind people that going back to 2002, people weren't text messaging all day, every day. So when you published an article and said this was the conversation, if you disagreed with that conversation, what you did was called up the editor or wrote a nasty letter to the editor saying, you misquoted me, you misstated what the conversation was, you need to print a retraction. And of course, the next day or 2 days later in the paper on page 2 that nobody reads, there'd be some kind of retraction saying this conversation never happened. Well, to our knowledge, John Swofford never said that these conversations about Raycom and ESPN and the importance of Raycom and their history with the ACC, he never denied that those conversations took place during the time of publication. So it is now very good evidence to show and suggest that the ACC did in fact breach its fiduciary duty, did in fact act against the interests of Florida State, and their principal concern was the survival of Raycom, not the economic benefit of its member institutions.
One of the so basically, Florida State actually has not quotes from the people who actually make the decisions, whereas the ACC has quotes from a message board with War Chant. So it's kind of like this. So and there was no retraction. So we have this. We basically have a paper trail showing one in our terms incompetence or a lack of fiduciary responsibility. Like you said, nepotism, which are basically negotiating without good faith. And one of the things that I broke down, and I told people, like, I think we said it on Renegade Report yesterday, I have zero problem with nepotism if it works. I personally, if I do things the right way, hopefully, my sons will benefit from nepotism with me. I unfortunately was on the wrong side of nepotism, but at least that guy went through the proper process. He was a GA, student assistant GA, receivers coach for a national championship team. Then he became an offensive coordinator because of who his father was. He didn't just go from being a student assistant to the offensive coordinator of one of the most popular brands in college football. But the question I haven't heard, is there anything technically illegal about that, or does it just not look like, it just doesn't look proper?
There are state laws or some federal regulations against nepotism, absent any specific bar, like what the federal government requires among the different administrations. Absent that, no, it's not illegal, but it calls into question the motives of the parties that are entering into these contract negotiations. So again, what's stated here is that the ACC took rights away from all its member institutions. That's the grant of rights. We're going to take this away from you. So now I'm the only one that holds all of your rights. I'm obligated. I'm legally required to make sure that I work in your best interest, that I get the best outcome possible. This happens a lot in financial planning. This happens a lot in situations where somebody is determined to be incapacitated and somebody else is in charge of their finances. Look, you can do a bad job as a fiduciary. It's not illegal to be a bad fiduciary, but the obligation is that as the fiduciary, you have to truly, honestly believe that you're acting in the best interest of your wards. And here we have direct quotes that John Swofford wanted Raycom to survive. And that raises the question of whether or not these deals were, in fact, in the best interest of the wards or the member institutions. And now, objectively, we can compare the ESPN ACC deals with the ESPN SEC deals with the Fox big Pac-12 deals that were all happening around the same time. And we can say objectively, not only were you a poor businessman, not only did you make the wrong call, but you did so because you were putting another interest, your son, ahead of those member institutions.
Which obviously as the head of the ACC isn't what your job is. Your job isn't to be the best dad at that point. Your job is to be the best commissioner. So again, for people who are following this, it's not illegal to be bad at your job. It's but being bad at your job can have other consequences than you just losing your job. It could be losing the conference as well. What are some other key takeaways that people actually, Luke, we did, this was brought up. And I think that's a little bit more of a stretch, but it might not be that far off for a less serious issue, and that would be Hunter Biden in Ukraine. But what are some other key takeaways that we can get from this amended complaint that FSU fans? And as I like to tell people, I think I found my niche in sports media. I am a guy who graduated in 3.5 years with a C- GPA.
Hey, that's good.
I wasn't necessarily smart. I did what I was supposed to do. You said go to this class, go to this class. I did what I needed to do. I think a lot of times everybody loves to use the big words. We like
Yeah, I'm giving my daughter some instructions.
Oh, my bad. Okay, cool. My bad. I thought you were. A lot of people like to use big words. So like when I see people who are like, when I break down football, I don't use a lot of the terms that a lot of other people use because we never use those terms when I was in the locker room. Like we never use a lot of statistics, and I'm not knocking these things. People have to do whatever they have to do to pay their bills. I just talk like an athlete, and I like to break it down. And after watching Neil deGrasse Tyson enough, if an astrophysicist can break something down to where I can get it, I think there is nothing more complicated than from how we get from here to the damn moon. So I pride myself on this show being able to break it down to the C- kids. And for the C- kids to be able to literally take this information, because this is what happens. Don't know if you do. I know you don't do this with your subscriptions and your football knowledge, but some people do. They take what they learn from these articles and from these shows. They go to the pub and they literally regurgitate what they just heard to their friends. And nothing wrong with it. That's why we get paid the big money. That's why we get the $9. That's where your $9.99 goes for some of these subs. But I want to kind of do that from a law perspective because a lot of these people are going to want to go and say, what was it? I said the preponderance of evidence. You used the word that I liked the other day. Comedy. I thought you were saying comedy. And you no, it's not comedy. That's when you go at the bar, you're like, no. God, you stupid. It's comedy. Come on, son. Like get in the game. So again, help us with some of these different things that we could get some points in.
So one of the big things that was really brought up in this and that we've laughed about since the ACC filing is this idea that the ACC has in their heads that FSU owes a fiduciary, or that Florida State owes a fiduciary duty to the ACC, or owes any privacy to the ACC. That was out the window as soon as the ACC filed its complaint. Now, they did file a few of their exhibits under seal, which means they asked the judge to protect some of the exhibits and not publish it to the public domain. Everything that's filed in the courthouse is generally available for review. We've got the Tennessee lawsuits we'll talk about in a minute. But at the end of the day, everything you file is public unless you specifically request for the judge to file something under seal. So the ACC did that with some of their exhibits, but their complaint lays out a lot of this dirty laundry that they're accusing FSU of now also airing. The difference is FSU doesn't care if this dirty laundry comes out because it's all about their relationship with the ACC that they want to tell to take a hike. So that was the first laughable part. This idea of a fiduciary duty from Florida State to the ACC is equally comical because the only responsibility that FSU has to the conference is to do a good job. And admittedly, I've seen this on a couple posts. Miami joined the conference. We thought they were going to be a powerhouse, and they have been subpar for 20 years. Clemson had a couple good years, and they're falling off. Florida State didn't survive the loss of Jimbo Fisher and didn't navigate that transition to Willie Taggart and now to Mike Norvell adequately. So there have been problems with the conference going up and down in quality, and nobody else, North Carolina, Wake Forest, Boston College, Syracuse, none of them have stepped up to create a more competitive environment for the ACC. So yes, the ACC is a subpar program or product on TV than the SEC, and that's unfortunate. But FSU is trying, Miami is trying. You can't accuse those programs of breaching their fiduciary duty because you can see that they're trying to get better recruits. They're trying to be better programs. They're trying to put a better product on the field. What the ACC has failed to do is they have failed to try to get better. They have failed to negotiate more robust deals with ESPN. They locked us in to a 14-year contract at below market rates when the contract was made. These have been bad contracts since its inception. And that's where the amended complaint comes out and shows this was a bad deal in 2011, 2012, and 2013. We're not talking about 2022 being bad. We're not talking about how could you not foresee that ESPN and the SEC would sign a $3 billion contract in 2023. Nobody could see that coming. But you could see that at the time that the Pac-12 signed a $250 million deal with Fox, you're sucking on the ESPN teat for only $150 million. That happened in real time. And so that's where there was a breach of fiduciary duty on the part of the ACC. FSU didn't breach any fiduciary duty. FSU has tried very hard to remain competitive, and we're doing it with one arm tied behind our back.
So the only way they would be able to give Florida State on breach of fiduciary responsibility is if we just said, like, actually, a perfect example would have been Florida State boycotting the Orange Bowl. Not saying that the ACC, that would have been a clear sign of you affected the conference based upon your greed. So that would be an example, correct?
Exactly. You hit the nail on the head. There could not be a better example. For you to be invited to one of the New Year's Six Bowls and be like, nah, we're taking our ball and going home because we should have been in the playoffs. A lot of fans wanted us to do that. But that would have been exhibit number one in the ACC complaint about Florida State breaching whatever alleged fiduciary duty exists. Now, let me go back to your point. That would be example of a breach of fiduciary duty. I'm not accepting that a fiduciary duty exists. There is an obligation to not talk bad about the conference, to not talk bad about the commissioner if there is no reason to talk bad about the commissioner. But we're in litigation now. It's time to start talking bad about people. So even now, as we go through the process of accusing the ACC of breaching its fiduciary duty and breaching its contractual obligations, even that is not any violation of any duty that FSU has to the ACC.
So it's kind of like I have a we got a stepfather. I should respect my stepfather. If I go make some money, it'd be nice if I gave money to my mom and my stepdad for the lights. but I'm a child. I don't like your responsibility is to make sure that I'm fed, clothed, and taken care of, not the other way around. Is that kind of just a very
That was my favorite line from the amended complaint. I think it was in paragraph 144 or something like that. The ACC exists at the behest and for the benefit of its members and not the other way around. That's what they specifically said in the amended complaint. And it's true. The ACC is not an entity in and of itself. The ACC is not due any respect or adoration. The ACC is a collection of 13 member institutions that is expected to manage and operate in a way that keeps those member institutions cohesively together. Nothing else is owed to the ACC.
Well, that. And for that, we all combine, there's opportunities for them. Their job, which they agreed to, is to negotiate in good faith on our behalf as we have all submitted to that. Now, somebody put up here. Now, I remember in the ACC's amended complaint, they said that Florida State doesn't have any. They think that we should not have voting rights. And Daniel Gorby, puts up, it's been circulating that FSU would not be allowed to attend the ACC meetings at Amelia Island in a couple weeks. Is that legal to not allow a current member to attend the annual meeting? So to not even show up, I get them saying we should not be allowed to vote, but is this something that is true, or is this something that is even legal to, like, again, with them excluding us from already being able to see the TV deals and all this stuff, is this something they want to continue down the path of excluding us from even seeing or hearing more stuff?
So one of the differences between the original ACC complaint and the amended complaint is introducing us to the term injunction. So what the ACC said is, now that Florida State has filed suit seeking their declaratory judgment action, so again, what we're asking is for a judge to decide an issue before we breach the contract. That's the declaratory judgment action. The injunction is another thing that they want the judge to decide before the case is over. They're saying, we want to establish some ground rules during the next 1.5 to 2 years that this litigation is ongoing. And one of those things that we want is for this spouse that is yammering about how bad we've treated her, that spouse doesn't get to participate in any of our meetings. That's an injunction. That's a request. That's perfectly valid and not unreasonable. The same thing happened in the Pac-12 as they were dissolving. Texas and Oklahoma, as they were leaving to go to the SEC, they weren't allowed to participate in any of the meetings. So no, it is not uncommon. And yes, it is perfectly legal and valid to say, we're in the middle of a divorce. While the divorce is pending, we don't want Florida State to have any say in how this conference moves forward, because the conference is going to try to move forward. The conference is fighting for its life. Florida State is fighting for its future and financial success, but Florida State will exist regardless of how this litigation turns out. The same thing cannot be said for the ACC. We are not certain that the ACC will survive this suit, Clemson's suit, North Carolina's suit, Miami suit, whoever else follows us. It is not a guarantee that the ACC is still a functioning conference 10 years from now.
That's so to answer your question, hopefully that answers your question, Daniel. We are accepting. I normally don't. That was a really good question. Now, starting February 1st, as we made the announcement on Big Games BS today, if you're a greenie, you're colored, and February 1st is our month. So everybody who's a part of the Den Media Group, I'm going to welcome you in. You get one too, Doug. You get to be able to come in and you get to celebrate Black History Month with us at Den Media Group because of February 1st being our thing here. But that was a good question there, Daniel. I appreciate that. Another one by Al Woody. And again, I think I know, but you would probably know a little bit better than me. One, has FSU actually seen the amended deal or the deal to extend the TV contract with ESPN?
Let me be clear.
Did they have access to it at any given time?
I'm operating under the information that's available to the public. So I've only seen what's available in the media, and I'm presuming that you have not dug as deep into this as I have. But there have been several reports, and the complaint alleges it as well. FSU has had access to the grant of rights, but they have to do so under the supervision of the ACC, with express permission of the ACC, at a scheduled appointment at the office of the ACC. So while there has been access, that access has been limited. There's no photographs that are allowed of the document. You can take notes. You can reread it over and over and over again. I know of at least 3 visits that were scheduled throughout 2022 where the lawyers and the members of the Florida State team have viewed the document. But I agree with what some of the other people were saying. If this is so ironclad, why are you so worried about who gets to see this? Now, I can see an argument for the ACC ESPN deals being more shrouded in secrecy, not being made public. That stuff has some details that would be very damaging if it was leaked to competitors. But a grant of rights that I've signed and that I'm a part of, it's pretty weird. I don't have a better word for it. It's weird that the member institutions don't get a copy. Now, there has been an allegation, and you mentioned the FSU message boards, that somebody out there posted in 2016 a copy of the grant of rights. The problem is that wasn't an executed copy of the grant of rights. And when a contract's not executed, it's not valid. And you don't know what other differences and changes have been made prior to it being executed. So while there is a version floating around, and the ACC is allegedly upset about that version floating around, we're not certain that that is the actual agreement that the parties have signed.
So even if it was, that means somebody has an idea of what might have happened. They don't, or what may be, but they don't know. There could be a whole amendment. There could be articles. There could be all kinds of stuff that's added to that nobody is aware of. Basically, I already have the solution. I know exactly what we should do. We need Mike Ross from Suits. We need Mike Ross to just go up there and read the contract, and then we'll have it because he's got photographic memory. Or we got to have some students with a photographic memory, right? Just have them go up there.
I have a friend of mine that remembers what I wore on each of our double dates in 1992 and 1993 as we were dating our Florida State girlfriends. There are people, the technical term for it, your new SAT word of the day, I like sprinkling these in, eidetic memory. The eidetic memory means it's basically, like you said, a photographic memory. They can read a document, and just like he did in his scene with the medical malpractice case, you can pick a page 236. That's John Smith, and that's where he had his surgery, and they botched the surgery because of X, Y, and Z. There are some very gifted people out there, and I really wish I had that talent.
Yeah. And going to no cab question is, why is the document so secretive? It's because it's ironclad. We already know, like, if you have an ironclad document, like, why would you show people this? Honestly, God's truth, my grandmother used to say this. My grandmother is a phenomenal woman. She is very worldly, very not vulgar, but she's very expressive of how she says things. There's no need to have a measuring contest if you know you have the biggest schlong in the room. She's like, and if you have the biggest schlong in the room and people want to have a measuring contest, you tend to just go ahead and just whip it out so you can end it. Funny story, presidential history. Lyndon B. Johnson is supposedly had one of the largest, had a baby arm, and they would have measuring contests in the White House while he was there. So basically, if it was ironclad, they would be Lyndon B. Johnson in this bitch all around. Like, if that, sure, watch, here, read it, do what you need.
Go for it.
I highlighted the good parts for you. Here, here's some other stuff, but they don't have it. And one of the things that I do think that Florida State has done a really good job of is make moves that to everybody else doesn't make sense, but were to set up for and it was always to set up for if something is to happen, now we have precedent to maybe move forward. So some of those different things. We've got some. Oh, she doesn't have anything there. Actually, doesn't show any. Oh, there she is. She's with her red Solo cup. What's going on, DK? How you doing?
I'm sorry, I'm good. How are you?
There we go. Hey, minus the bullshit, my life is great.
Making sure. Amen to that. I feel you.
That was a good question. Okay, so what is us adding the Swafford crew do to this right here? Does it just basically, because sometimes when players mess up, does this be like, did they just look at John Swafford and be like, you and your damn son again? And is this basically Florida State saying, please don't make us continue to do this? Or do they sacrifice? What exactly did that do to strengthen our case?
You want to jump in hot, Danielle?
Sure, why not? What didn't it do? That complaint is so detailed and mentions them. You'll see new sections pop up with their names more in depth on basic allegations we had already alleged in the original complaint. Now we're just doing it more specifically, and we're throwing out a lot of names, including Skipper Swafford and his son. Everything that went on behind the scenes. It adds a lot. It gets to the point, honestly, with this where the allegations are so damning that I'm surprised he's not been added as an individual, defendant at this point, being honest. It beefs up the case. It also broadens discovery on this. And we'll be able to get into more detail with discovery and asking questions about those conversations and the things that went on under the swaying pine trees of North Carolina. I think that was my favorite paragraph, but we'll be able to get into that more.
You said something that I haven't heard before. I just, again, I think petty, my goal in 2024 is I'm not petty. Petty doesn't pay, but I'm deliberate. It's a difference between being petty and deliberate. I don't ever want to accidentally offend people or harm them. That is never my intention. I enjoy offending people on purpose. So if I do it, I want you to know that it was on purpose. And this, we could add John Swafford and his son to this.
Yeah, I mean, you really can. Florida State, I would say, it's possible. I don't know with North Carolina law and everything else, but yeah, if there are damages to Florida State stemming from corruption, bad dealing, self-dealing, that kind of stuff that they were doing, you can.
And let me explain why also that's valuable in this situation. Oftentimes you don't want a current employee to be in a deposition because they're going to try to protect their existing job. With John Swafford being out, at this point, he knows he's in some shit. But at the end of the day, the best way to come clean on this is to be truthful and honest, because he dang sure doesn't want to add a contempt of court or perjury charge to all the stuff that he's done. So in a deposition, he's going to be very forthright about his conversations and the truth of what was going on, because there really isn't any way to sue him for tortious interference. There's not really any way to recoup $83 million from his pocket. At the end of the day, he's not interested in whether or not the ACC survives as an entity or goes on, because he's retired and he's out. So adding him is a very interesting strategic decision, but could be very valuable because you're probably going to get the truth out of him.
Yep. Concur 100%. That's just the way it goes. It's the more knowledge.
Even if they don't add him to it, he can still be deposed.
Certainly.
In this, because he was a part of the contract.
And will be.
Not could be deposed. He will be deposed.
Exactly.
Do you have to be an attorney to depose people? Yes. Or can anybody ask the questions?
No.
It is.
You gotta if I pass the bar
in the next 18
do I have to have a Juris Doctorate to be an attorney, or can I just pass the bar?
I know somebody in Georgia that didn't get an accredited degree and passed the bar and is an attorney. but that's a very rare exception.
Yeah, like Doug said, that's very rare. This isn't Suits.
I ain't that smart. I just really want to be in there. I just want to be in the room. And one of my favorite movies is Menace to Society. And there's this scene where he's not being deposed, being interrogated by the police officer, and he trips him up and he says, I can't think of the guy's name. It's just he's dark. He looks like he just looks weird, but he's like, you fucked up, right? And he just pointed at him. Like, you fucked. And the guy is trying to fix his words. He's just like, nope, you done fucked up right now. You fucked up right now. And I just want to say that to somebody in the room. Actually, you know what? I don't have to. They can let the attorneys ask the questions. When he trips up, AD offered, I volunteer my services for free to just be able to say, Bill Duke, that's the guy's name. Bill, look, for those who are listening or see, look up Bill Duke and just ask yourself, do you want to be interrogated by a guy who he was big then too, and he was dark, and they were in a dark room with a little bit of light? It was very intimidating to see. But we talked about a lot about fiduciary responsibility. I love saying that word. Ever since I got glasses, I feel like it hits harder.
I need to leave you for 90 seconds
alone, based upon the information and the facts and what was printed in the articles and what we do know. I'm reading this. The Raycom Sports Partnership has cost each ACC member several millions of dollars and continues to depress the value of their media rights and the cost and blah, blah, blah. Divided, it costs us $3 million. It's one thing to be bad at your job, but if you're supposed to be making me money, isn't it bad or shows the lack of you being able to handle your fiduciary responsibility if you consistently lose me money?
Yes, that goes back to the fiduciary responsibility and what we're alleging. And with the amended complaint that came out, that you get to, I think it was page 2. They start mentioning that word self-dealing. That's what this was doing. And the ACC, we weren't getting any money out of it. We're getting nothing out of it. There's no consideration for any of this. And they're doing this in bad faith behind the scenes. So yeah, that's not a contract. You're not doing anything on my behalf. Like I said about fiduciary roles, you have an obligation to fulfill your duties in the contract to my benefit, just as I do to you. And if you fail, you fail.
Can you close my door? Sorry about that. My fiduciary responsibility that owes me nothing is making a lot of noise and doesn't want to close the door. But all right, so we asked Doug a lot about some questions. From your opinion, especially those who don't know, Danielle Kelly is a licensed attorney in the state of Florida. She has sued government entities before. She's been into situations like this. She's been on both sides of all of this. What is your opinion of the amended the amended complaint that Florida State has filed, and kind of just give us a quick summary of that, and then I want to get both you and Doug as steps moving forward.
Reading it, it's obviously a different page link. There's a lot of new sections. There's a lot more specific allegations in this complaint right now. It absolutely details what Florida State knew with the Raycom issue, with the Swofford connection, with Skipper, and the self-dealing that the ACC was doing. Like I said, you get to page 2, and that's where you start really, you go through it and you even learn that the ACC network struggled to even launch because of the Raycom deal, which Swofford was involved with both. It's actually a very big deal because it shows, James, I'm being honest with you, with the new allegations and the facts as presented and in detail as they went with the, connection with Swofford and what the damage to the conference members at that point. How does the ACC even survive that? It's huge. It's absolutely huge, because I'm going to tell you, and I can't speak for a judge or precedent or anything. I'm just saying I live in Tallahassee. I've practiced in front of this judge before. He's very broad on discovery. He is a former civil lawyer, and he likes to have all the facts. He likes broad discovery. A lot of judges and attorneys love that because we want to get to the truth of what happened. I think at this point, that amended complaint is so detailed and opens so much for us to do with discovery. They would be really wise to just get out of this now. I really don't understand why they're not, but I do, because they don't want a mass exodus. But it is a really big deal. And they threw everything out. Basically, they said, we're going to start naming names now. And don't make us add you as defendants either.
So basically, so to quote another movie, that was a great movie, New Jack City, on the stand, Nino Brown. This is bigger than Nino Brown. If I'm going down, everybody's going down with me, and I got names to take. So basically, you don't want us to get up there. We got to snitch to be able to get out of this. But now Luke does bring up this point, and valid. Court of law should not have so much room for interpretation, but that's the problem. Is everything it has nuance, and so when there's nuance, that's why you try these things. And if I remember correctly, I think you brought this up too as well, Danielle, and I know Doug brought this up. There ain't a lot of case law for this. Am I correct on this, or is there like a ton of things that you can go to point to
that? There's not. And honestly, what there is, FSU is citing and needs to, would be the lawsuit with Maryland with the ACC deal. That is, FSU is continually, routinely referencing that because, like I've always explained, lawyers work in precedent. That's the judicial branch. We don't pass law. We interpret already existing law. So we have to look at precedent. FSU is definitely looking at the way the ACC has handled the Maryland suit and what happened. And as a result, we got punished with the severe withdrawal penalties anyway. But, it's not about interpretation at this point. It honestly, it is, but it isn't. It's not. We're not inventing law. It's already been passed, and we will, use that precedent to go forward. The Pac-12 would be another area of precedent I would use.
So with most of this stuff, a lot of times, most cases don't ever see the court anyway. This is really looking like it's leaning toward a settlement. Mm-hmm. With that being said, is Florida State, with this information right here, based upon how we feel like we might be able to get them down a little lower than what some people may have thought the original thing was?
With those allegations, I'm going to be surprised if we have to pay much at all. I'm being honest. I mean, you're talking about really, and it comes back to antitrust. It comes back to self-dealing. It comes back to everything they're alleging is so severe that if we do get to a discovery process and we can prove all of this, and I know Doug and I have talked about, we haven't even gotten into the unprovoked lawsuit portion of it with them, with what they filed in North Carolina. We could make this very difficult from them to the point that they just want us to go away, much like they did Maryland. So,
which gets us to another white question from King Spleen. Again, don't take offense. You're just not a paid member, so you're not green. So you're white. That's YouTube's fault. That's not me. Referencing the judge in Florida, but it's a really good question. Referencing the judge in Florida, are you guys confident that it won't end up in North Carolina or federal court? Danielle, you just brought up something that I have not heard. Again, it is not because it hasn't been said. I don't listen to other podcasts. It's actually three podcasts that I listen to when I get a chance. One of them I'm actually on, and that's Sporadics, Renegade Report, and Dope Talk. And I don't think you've done CJ's show yet with Dope Talk. But I haven't heard about this. Tell me, I'm assuming we kind of talked about it, but I did not know there was a term for it. What are you talking about, Danielle Kelly? And can you explain this to the people? So, again, remember, we're not the pompous group here. We are C- students here. We want to be explained on a C- level.
All right, C- level, and I have notes. I'm trying to go back and find the paragraph that it's actually in. But anyway, Florida State adds a section in the amended complaint about an unprovoked lawsuit. What happened was the ACC filed suit the day before the Board of Trustees met and decided to file our lawsuit. Our lawsuit was, of course, already drafted at that point and was filed that day. The ACC, when they did that, FSU references, talking about precedent, FSU references the Maryland lawsuit in that too. They really needed to get the input of their members. And FSU, I think, and Doug, correct me if I'm wrong, alleges that they even needed a vote on that issue, and they didn't get it. They just filed suit.
So, question real quick. Sorry to interrupt you. So, what that means is the ACC, forget FSU to the side, but without asking North Carolina, Miami, all these other schools, decided to thrust us in our hard-earned money in the court into what we may think is a frivolous lawsuit. Is that their fiduciary responsibility to at least inform me of what happened? Now, what if that did happen? What if people were informed that they were going to sue somebody about a lawsuit about something that hadn't happened yet? I guess, does that strengthen that case?
It would have been better. I mean, for them to inform them and let them vote, it would have been.
I just know it didn't happen, but I'm just saying they can't. It's no way around that, right? There's no way for them to say that they did that they did the right thing, a uniform thing.
Their obligation is to represent their members, and they've claimed that in their lawsuit against Maryland. That they have to do what's for the member institutions. The member institutions had no input into that. Regardless of their constitution and bylaws, they just ran to the courthouse first to get it done so they could say, hey, we need this case in North Carolina. It's a typical ACC mentality, doing things stupidly. So, I think that will come back to bite them. I would file a motion to dismiss. That would be me.
So going back to what we talked about on the show last night, there's this this idea of comedy or comedy. You can pronounce it different ways. The first filed lawsuit is typically between two courts going to be given deference to the first filed lawsuit. If there's two claims based on the same issues, both courts don't generally want to waste their time going through the same motions and deciding the same issues on two simultaneous cases that have been filed at the same time. One of the exceptions to the first filed lawsuit getting precedence is when it's purposely and improperly filed just to gain a tactical advantage. So to Danielle's point, a vote wasn't had, a meeting wasn't had, a vote wasn't had, and this was filed before FSU did anything. So the Florida judge has every reason to look at the North Carolina lawsuit and say, we're not going to give deference to the North Carolina lawsuit. We're going to have the Florida lawsuit.
Yep, absolutely.
So let's just say this. I don't think it gets to this point, but let's just say everybody we play this. This is our this is game set. This is the finals, NBA finals here. We're going to their home court. They win the game on their home court. We win. They beat us in North Carolina. We beat them in Florida. What happens?
Laws from conflicting jurisdictions. Yeah, that would be fun. This is where the situation comes up that things could ultimately end up in federal court, because eventually the federal court would have to get involved in that, because you got two conflicting jurisdictions and two conflicting laws. We would have to either on appeal from a state court or whatever, however it gets there, have federal court get involved in that point.
The good news is that at the state court level, there's a lot of connections to local people, to local relationships, to friends. That's where you get a lot of influence from the guy that you're golfing with on Sunday. As you move up to the appellate courts, to the district courts and the federal court, you lose that good old boy mentality, that good old boy relationship. And I'm not suggesting that either North Carolina or Florida judge is subject or could succumb to such influence. I'm just telling you how life has worked in my 23 years of experience as an attorney. So yes, while I go to church with one of my local judges and I can sit down with him and talk about non-case specific issues all the time, There's not a lot of buddies that I have. I have one drinking buddy on the Georgia Supreme Court. There's the influence decreases. So as Danielle says, if we get to a point where we have two competing and opposite conclusions in North Carolina and Florida, there are appellate courts and federal courts that are going to resolve this conflict.
Yep.
So sometimes all it takes is one entity or one person to be bold enough to stand up to somebody. For others to say, you know what? Damn it, something doesn't smell right here. And with the numbers that were thrown around, and I think one of them was pretty astronomical. It looks like North Carolina is starting to ask questions, and again, not sue, but they're making very similar moves than what we have seen take place. Can either one of you kind of explain what you kind of see other schools doing and what North Carolina is doing, and how would that affect if another member institution in the state of North Carolina or multiple member institutions? I remember, Doug, me and you talked about, and I think I talked to you too as well, Daniel, about if they have to fight on a whole bunch of different fronts. How does that affect any of these cases? And does it eventually, but ACC just say, you know what, instead of me, it's cheaper for me to just go ahead and get these buyouts as opposed to fighting 5 battles?
Either Doug, you can take that. All I'll say shortly is North Carolina has a fiduciary role. UNC has a fiduciary role, as all the member institutions do, to deal with the financial gap, to deal with the things they're doing, and they're starting to call out the ACC as we're out there taking all the arrows for it, but now they're starting to realize, okay, well, we got a job to do too. So
I have three different points I want to mention real quick on this. The first is, this goes back to why the ACC filed its amended complaint and sought the injunction to stop Florida State from participating in any conference activity. That's what's going to chill these other members from jumping in the fray. That's the one thing I can say the ACC has done right. They have tried to prohibit this from becoming a two-front war. There's a reason why a two-front war is so difficult to fight. World War II was so challenging because it doubles or even triples the resources you need to fight both of these battles at the same time. So the ACC is operating to try to make this limited to just battling Florida State. To your point, 100%, having a multi-front battle, battling 3 different lawsuits, is going to churn through their resources very quickly. The second issue is in the issue of having the buyouts and talking about why don't they just resolve this. I think that's really the few opportunities the ACC has to salvage their existence through this process. From the time we joined the ACC, it was always viewed as a basketball first conference. Fine. Embrace that. You can't compete with the football powers, and Florida State wants to be one of the football powers. You get 3 conference members to pay $200 million, $150 million all at once into your coffers, not waiting for the grant of rights, but to pay $350, $400 million at once into your coffers. You can survive being a basketball only conference. You can survive whatever turmoil is going to come through conference realignment. So let's go ahead and wrap this up. Let's get UNC, Florida State, Clemson, Miami, Virginia out of the ACC. And they've got $800 million that they're sitting on in order to get through the next 5 years as they devolve into a second tier conference.
Amen. All of that. All of that. I mean, that is perfectly said.
But I'm not in charge of the ACC.
If you were, we may not be here. I mean, it's just inept leadership at its finest. So but yeah, what Doug said, the injunction, that's huge. It's to chill. It's a chilling effect. That probably is the only thing they've done right so far in this entire lawsuit.
I think it's sometimes when you're in relationships and you start hearing words that sound very similar to what other people's relationships with friends that have gone bad, their friends' relationships gone bad. Again, this sounds very much so like a few years ago or not too long ago foreshadowing of what's to come. I think that anyone who grew up a North Carolina fan and grew up in the Atlantic Coast Conference has fond memories of Jefferson Pilot ads, sail with the pilot, and feeling of nostalgia for the ACC. But the reality is that athletics nationally has changed dramatically since the ACC was put together at Sedgefield Country Club in Greensboro. And as a result, it is incumbent upon the leadership of the university and the chancellor, as well as our board, to do what is in the best interest of Carolina. The Board of Governors just recently made it clear that the economic considerations should be paramount in that. I think that we all need to just realize that it's a new day in college athletics than what was with the ACC, what was created with the ACC. And like, again, that would strike fear to me right now, especially considering a lot of the different things that could potentially come out in a lawsuit with the state of Florida, with Florida State in the state of Florida. You're gearing to have more ammunition given your way. So Al Woody asked another great question. Would the other institutions have to file complaint in their respective states?
But before we answer Al's questions, let me go back and address one thing that you were talking about. I want to underscore, we're all similar ages. We all experienced Florida State through the heyday of the 90s. Let me remind you that in 1994, every single one of Florida State's games were televised, except I think one. I was a member of the Marching Chiefs. We would travel to all of the away games. I remember there was one game I didn't get to watch because it wasn't on TV. That no longer is the case. And that was because Florida State was amazing and they appeared on TV. We have recruits that would come to Florida State just because they wanted their mamas to watch them on TV and they knew Florida State was their best chance to get on TV. They didn't have the robust broadcast structure that we now have in 2023 or even had back in 2012. You can now get every single, you might have to subscribe to the CW, you might have to subscribe to Peacock for the NFL playoff games, but you can watch every game that your team is a participant of. And let me say, this is one of those reasons why these contracts are getting unwieldy and they're getting expensive, because it costs a lot to send a team of 70 people to a game to broadcast. You know, not a lot of people are watching Cal versus SMU when the ACC schedule comes out next year, but they still have to invest in the production of that program to make sure that they have the FSU Clemson game. So there is increased expense. I understand why this is such a big deal, but that's what when they're talking about a new age in college football production, that's what they're talking about. There used to be 20% of the games every Saturday on TV. The other 80% weren't on TV. You didn't have a choice to watch them. So you have to understand that when we're talking about these changes that have been made, that's what they're referring to. Every single game is on a network. You might have the F team broadcasting it. You might have, people that are speaking in words that you can't understand and using similes that don't apply to the situation, but at least you can watch your team on TV now. And that's where these expenses are going through the roof.
And a lot of it had to do with that's why we play games on random days. I remember one of the beautiful things that's always echoed and talked about, like right around, it's that sweet spot sometime in October where it's like there will be football on all but 2 days from now until through Thanksgiving, and you're it's like heaven to me. Like the amount of football that I watch in the fall is not, it's just crazy. I watch a lot of football.
It's not healthy,
but I love it. It's definitely got to be. I definitely, if I didn't do this for a living, it probably would be. I would definitely be looked at. People would question my sanity. Like, why are you? You need new hobbies. But I mean, it goes to a great question, and I know we don't have you for that much longer, Doug. So I want to get into this question because we've answered a little bit, because we can't really go too detailed because North Carolina has done nothing but paint elegant soliloquies and very, very good very they edit very well. They did not put the wrong words in there. They did not put Boston College University and stuff like that. They made that. That's the chancellor for you right there. Or, but Tennessee, the NCAA has attacked almost everybody. They have attacked Florida State. They've attacked Georgia. They've attacked. They even got Colorado a little bit. They didn't get Deion too bad. They just let Deion know we here. But they hit Tennessee, and Tennessee is a little bit different. They got hit with level 1, level 2 violations. Level 1, for those who you don't even need it. Level 1's not good. Level 2 is not as bad as level 1. But you don't want to be in that territory. But then Tennessee did something that Florida State didn't do, or opted to not do. Georgia opted to not do. Most people take the charge. And now I have it on good authority to know that the NCAA is far from done with what they're trying to do with NIL stuff. But what did Tennessee do, and what makes this kind of different or interesting?
So you'll remember Tennessee is already coming off a recent suspension or recent probation last year from some concerned issues, and I didn't get into all that. I just know they're coming off some issues. They cannot take a second violation in such short order without it being a program destroyer. So they have gone on the offensive, and they've filed a complaint along with Virginia, actually setting out a complaint as to why the NCAA is in violation of the antitrust laws and can no longer hide behind this perception that they get to rule over the NCAA. So they have affirmatively used this NIL issue as a wedge to say, look, you were informed after the Alston case that the players were going to get paid. You had the opportunity to step in and create guidelines and regulations, and you failed to do so. You should have put in actual bylaws, new bylaws, but you didn't. You put in some phantom regulation, safe harbor provisions. And in doing so, you are now using that gray area to come back and try to assert your authority over the member institutions. And we're no longer going to allow and abide by the NCAA claiming to be a non-competitive organization that isn't in violation of the Sherman Act. Specifically, what they're pointing at is this idea that individual high school athletes have to commit to a program first and then discuss NIL opportunities. That's an improper restraint of trade that suppresses the value of NIL. A player like Jaden Rashada should get to go to 3 different schools and say, tell me what I'm worth. And so this concept that the NCAA has instituted saying, okay, fine, we'll let you pay players, but you can't use the NIL space as inducement for them to sign with you. Tennessee is coming up and saying that is absolutely incorrect, and you are wrong for thinking and presuming that you have the authority to make such laws. And while we're at it, let's just go ahead and make sure that we pull your pants down and show that you are in fact violating antitrust laws and should not be allowed to continue existing.
So yeah, and I let me just say what he said seriously, and I know I had talked about this on the show with you the other night, James. All this stemmed from the Alston decision, of course, and it because the NCAA and their inept ability to regulate anything is trying to regulate around the fact that they lost in Alston, and they're trying to regulate in a different way that's still violating antitrust, and they're getting called out for it. And that is, I predicted that was going to happen as soon as Alston came out. I'm like, watch them come up with new regulations now and not enforce or over enforce, or the portal is going to become an issue, or this or that. And you're going to end up here at the Supreme Court, and what lawyers work in. The precedent is the same. It is an antitrust violation. They needed to develop a new system and fix it. They didn't. They spent time lobbying Congress for a law that was never going to happen instead. That's what the NCAA does. They're a lot like the ACC. They're my 2 favorite people.
Very similar.
Which brings me to the inevitable. Like my guy Thanos. I'm inevitable. If I'm the AC, you're the ACC, and you're looking at this, and you're seeing this, the NCAA is fighting multiple battles on multiple fronts, which is ironic. Just to use a military, it's not military. It's just it's multiple. It never works. Germany was doing really, really good until they went to go try to go at Russia. Then they gave them 3 fronts. You had the Pacific, even though Japan was handling that. You had Europe, and then now you have Asia, Russia. But like they spread out too thin, and then they got caught. It's looking like the NCAA is going to litigate itself to be obsolete. And right now you have 2 major conferences that actually made moves to make themselves relevant. And that will be really, we might as well call it the Power 2 as long as the NCAA remains. And one of the Power 2 is fighting the NCAA right now, which if other people get slapped with violations, they're probably going to try to do so too. And I never really thought about it in the manner in which you said. It's actually ironic. We say the youth are the problem with America when we're literally not allowing them to practice principles that we teach them of what America was founded on. Capitalism. Like that is like literally the way you described it is textbook capitalism. I should be able to go from here, here, and here, and somebody should pay me for this. And whatever. I'm a bad. Tanisha asked, were coaches fired? I'm assuming you're talking for the Tennessee thing. Yes, coaches were fired. Jeremy Pruitt was like put on like this crazy ass show clause. And everybody who's Florida State fans, you remember Jeremy Pruitt. We give him a lot of credit for a lot of things that Mark Stoops built. But he did win a national championship with us. But he hasn't won one of those since he's left here. But good coach, very good recruiter, too good of a recruiter. Got him popped by the rules. But why wouldn't the ACC just kind of play it cool and just, I mean, I know they've tried different things, but like, damn, it just feels like if you would just ride it out, you might be okay into a new, the formation of a new governing body with a Power 3 or a true Power 4 if you want to bring the Big 12 involved. Because I've always said there are 50 schools that could compete for a national championship consistently over a decade. It's really not that many. It's just 50 makes you be able to schedule stuff. But like
64.
Okay, 64. We'll go with the NCAA. We'll go with March Madness type stuff. But like, why wouldn't they just? Is there a way for them to just kind of ride this out, or is it because it does look like the NCAA is like going to be obsolete? Very soon.
The ACC could be the king of the second tier conference if they chose to do so.
That is.
Or we have, let's see, let me bring up I'm a lawyer, so I'm not good at math. 64 divided by 4. The ACC could be one of 4 16-team conferences. The ACC would be the second or third or fourth strongest of those 4 16-team conferences. But those 4 Power 4 conferences could coalesce and be the 64-member Tier 1 NC New Age, whatever it's going to be called, National Collegiate Association of Serious Academic Institutions, whatever. So you could have 4 16-team conferences. I think really a lot of people are looking at 20 to being the series. So I could see a Power 2 that has 2 20-team conferences. That would be the Big Ten and the SEC. That is probably the second most likely and most reasonable solution to have that number 40 that you mentioned. If you think that there's 40 or 50 truly competitive teams in football and in the Olympic sports, you could have 2 20-team conferences that are ready to clash as a separate AFL organization.
Well, I know you got to go, Doug. You got another pod to do, man. I appreciate you coming on and clarifying this. What you drinking tonight?
So this is something called Coconut Cartel. Your fans it's a Florida company. It's a rum, but it's made with coconut water. And so it's very smooth, goes down very easy. Very, very comfortable. But out of Florida, a company called Coconut Cartel. Highly recommend, 5 stars. 10 out of 10.
Like rum.
You don't
We
even
love
need to
rum.
ask what I'm drinking. You already know.
Vodka.
Mick Ultra.
Mick Ultra.
James knows from the
Mick Ultra,
tailgate.
man.
It's a thing.
Yeah, I've tried. I failed. I'm not getting white people beer anymore. It gets out of hand. I did not know. I drink liquor, so like I like liquor. We have tons of liquor at my tailgate. Liquor flows. I just assume that why drink beer when you can drink liquor. And boy, am I wrong when it comes to certain things. And I thought I had a lot of beer. A lot of beer is a little beer.
Leo's
on a hot Florida day. But what podcast is that going on at 8?
We're going to Big 12 Mafia.
Yeah, me and Doug are supposed to do Big 12 Mafia at 8. So,
Okay.
yeah, it's the first time. I wish we had longer because this is the first time I've gotten to be on with Doug finally and go over all this stuff. It's, and there's so much going on, everything from Congress to the House case to the Department of Justice to what Tennessee's doing with the NCAA to FSU and the ACC. You could talk for hours and hours. It's crazy.
Bottom line is just all this could have been said, but it's American history. It's American as apple pie. Nothing's ever done for the right reasons until it becomes a fiscal issue and it gets taken away. When all you had to do was like, it's wild because everybody's complaint was, well, what happens when they pay taxes? Do you really want to become an employee? Well, now you lost everything, and now you lost those opportunities. And if you would have just said, here's $50,000, I think a lot of people would have walked away and been like, you know what? Fair. But now it's going to cost a lot more. And as with everything, the market corrects itself. The market dictates what these guys are worth. So I appreciate you guys. You guys go check them out on all the other shows. And any parting things you guys want to say?
Let's wrap up with guesses on how much and when.
All right. You first, DK.
I mean, it's speculation at this point. I don't know how far FSU's in it to fight, so we're going to go all the way. There's no question there. If they're smart, and I hope they are, and I think settlement is the best option, especially with the way we came out swinging. I say sooner rather than later. I'm still, I got to get y'all's opinion on this because I was between 100 and 200. For a long time, but there's some really bad allegations in that complaint.
Since you're trying to hedge your bets, I'll be more concrete. 150 million, August 16th.
I love it.
People in the chat who've been following me for quite a few years. What is my number? Go ahead and put it in. I want it to be cemented so nobody thinks that I'm copying off of Doug. They can tell you what I have been very specific about the number that I have said. I won't say for reasons why, but I've been specific for the reasons for what I've said. 150 is the number. And I do believe, August is a little more specific than I would get. I was going to say before football season, because I personally don't see Florida State being in a 2026 football season contract. And you need a few years to be able to make sure that you can secure those, which it's not unprecedented that for us to say we're out, to be able to get out, finish the 24 season and do what we need to do for 25. We've seen Texas and Oklahoma actually expedite their process of getting out of the Big 12 and going to the SEC. But I do believe Florida State in 2026 will be in another conference. So
that's why I picked that date specifically. ACC knows that Florida State is the crown jewel, and they want to do everything they can to keep them as long as possible, regardless of the money. So by waiting until April or August 16th, the notice goes in, FSU plays a 2025-2026 season and is out by 2027. I don't think that they compromise with a good figure and also give up a 2026 season.
Understood. At the end of the day, it's not about the money, but it's always about the money. So Appreciate you guys for coming on, man.
James
Great Noel.
Take care, James.
We'll see you guys later when there's some more legal news that comes out.
Let's do it.
Always.
All right. That's Danielle Kelly. I'm Doug Rohan with Rohan Law. Did Media Group Law and Order FSU edition. Make sure you check it out. Please go retweet this. Again, these are not to just do extra stuff. There's a lot of legalese that gets thrown around. Want to make sure that we're all as educated as possible, so that we can be able to go speak intelligently about these things. It's nothing better than to beat a troll with everything else. My guy Fatal Jedi says, what's the other show? I think he said Big 12 Mafia is the other show on and I don't know where it's at. So I just know they had to do that. So appreciate you guys. I'm going to go get some chow and take care of my child who pretended to be sick. And I will see you guys. Tomorrow, 11:30, Dope Boys Chop It Up. Travis Johnson is going to be a very fun episode. I don't know what's going to be said. There is no script. I have another Dope Boys plan for next Thursday. I will drop the person who will be that here soon as I get it solidified. But again, really dope episodes coming up. A lot of people have liked that. Great feedback. Going to be some great stories, great moments. And we actually have some more content from our Dope Boys Chop It Up shows. I have got a cartoon. We have a cartoon that should be dropping this weekend of one of the funniest moments. So I think it's going to be awesome, man. Again, I appreciate you guys for chopping it up with me. Make sure you go and like the channel, subscribe to the channel if you're new. Consider becoming a member. The growth has been crazy. September of 2022, this channel had 250 members, 250 subscribers. January 1st of 2023, we had 1,200. We're currently well over 5,000. I think it's 5,163 when I just checked it. Let's continue to grow it, continue to vibe. Appreciate you guys. Y'all have a great evening.